opportunity to draw the attention of the state to Nnamdi Kanu and the apparent injustice in the prosecution of Nnamdi Kanu. The judge is Yoruba. The prosecution team, all of them are Yoruba. The Attorney General is Yoruba. Mr. President is Yoruba. It appears that, for some elements within the Yoruba, community are looking at this as a new civil war between the Yoruba and the Igbos. It shouldn't be like that.
Yeah, but you're the one who's saying that.
No, but it's the reality.
No, well, I mean...
It is the reality, Charles.
Sanctions against their lawyers.
Did they give Tinubu sanction? Did they give Tinubu sanction when Tinubu was protesting himself?
More on this. I'm joined now in the studio by the member of the House of Representatives under the Labour Party, the Honourable Obi Aguocha, who was in court when today's drama unfolded. Thank you very much indeed. Good to see you again.
I'm happy you know that I'm a Labour man.
Yeah, well, you are.
Because for life. I'm not wearing my Labour insignia here. But.
Well, I'm going to get to that because there is another drama that's unfolded. In fact, you're in the centre. I mean, there's drama with Nnamdi Kanu, there's drama with the Labour Party, but we're going to get to that in a minute. But you were in court today when Mr. Kanu, for want of a better term, purged his legal team. How did it come to that? Well,
he had discussions with the legal team yesterday, and all of us were shocked when we came to court and the Honourable Attorney General of the Federation previous, Kanu Agabi, announced to the court that himself and the legal team, especially those of the Inner Temple, are withdrawing. And the judge also was shocked and asked Nnamdi Kanu about it, and he concurred that for now, that he would take charge of his defense. Doesn't mean that if tomorrow an opportunity arises, that lawyers will not also be part of it. So, but for today, probably tomorrow, he would take charge of his defense. So that's what happened in court. And
were you surprised?
I was pleasantly surprised.
Pleasantly or shocked?
Well, surprised and shocked at the same time. In terms that none of us knew about it. I came to court, just like I've always done, attend the court hearings and all the stuff. And I sat there listening. I kept making the contributions. It's just between Nnamdi Kanu, the prosecution team and the defense team, and the judge. So as of today, the lawyers have virtually stood down. Whether they have given Nnamdi Kanu his case files, I do not know. But when you go to section 36(6)(b) of the Constitution of the Federal Republic of Nigeria, which are actually a crucial provision towards fair hearing, specifically to persons who are charged with criminal or capital offenses, is the constitutional right of Mr. Kanu to decide to take over the defense of his own case. It is also his constitutional right that adequate time and facilities be provided for him to ensure that to ensure that he has adequate defense.
Yeah, but I don't think the issue is whether or not. I think everybody knows he's got constitutional that right, which is why the judge allowed it. But the question is, what's the thinking behind it? I mean, things aren't going well when you fire the people who are supposed to protect and represent you in a trial, don't you? I mean, did it appear to you to be an act of sort of visceral rage, impulsive, chaotic purge that wasn't well thought out? Or do you think he thought it out?
If you look at the statements made by the Leadership Agabi Kanu, he said after the meeting they had yesterday that the information was told them that they were going to be debriefed and that they respect the rights of Nnamdi Kanu.
No, I understand that, but I'm
trying
to get to the backstory.
No, that's what I'm saying. But if there was anything that happened otherwise at that meeting, I was not in that meeting. I only showed up.
But I mean, you would have heard things. I mean, you talked to him.
No, really.
You guys normally hug each other at the end of the trial. At the end of the day.
At the end of the day, we sat close.
Did he whisper anything?
No. But at the end of the day, he was actually, he was actually led through the judge's chambers, to be evacuated back from the Federal High Court to the detention center. So we didn't have enough time to discuss in court. To say, because he's often brought to court 10 minutes to 9, and the judge comes out exactly about 9 dots. So there wasn't that much of a time beyond the camaraderie.
We obviously saw the statement. I was actually hoping that we would hear that clip from the lawyers, because they made a public statement, which has been run on a rise several times today. But I mean, is there anything beyond that public statement that might have said perhaps out of camera to you?
No, nothing yet. I've yet to be informed otherwise. But I know that tomorrow he may be meeting with some of the current legal team that were debriefed. Maybe possible some additional members of the legal team to go forward, at least to have some people who will surround him and be giving him legal advice where necessary, and the authorities that he will need to proceed with the defense of his case.
Right.
But what we are saying, crucially, Charles, is that Section 36(6)(b) is essential that it appears that the government is rushing his defense by giving him 5 days. He's already made known to the court, and the court has given summons to 23 witnesses. He will need to spend time to discuss with those witnesses, and where those witnesses are not compliant, to ensure that the court compels them to, through subpoena, to come and testify in court as to their knowledge of events from the time he was arrested to the time he was extraordinarily renditioned, and from the time the trials also began 5-6 years ago. So if you're going to rush, the prosecution has had more than 10 years to prepare for this matter. They've arraigned him on several charges, withdrew several charges, and rearraigned him. They've had adequate time to present their case, and they have rested their case. The defense also requires adequate time to be able to present their case. You cannot say in a capital offense, a criminal trial that has so many significance, not just for jurisprudence, but the social and security dynamics in Nigeria, that Nnamdi Kanu is expected that is within 5 days to be able to put a defense. If you're going to railroad him, just like the court in their determination, the court says he does not verily believe that access to lawyers at the DSS facilities may be videoed, may be eavesdropped. So he agreed for 3 hours. That was yesterday's meeting, for himself and his lawyers to meet at the judges at the court 7 specifically. But if you go to court 7, there are video cameras, opportunities to also eavesdrop. I'm not saying that his lordship was in his chamber, but what if he was in chamber? Who else was in chamber with him to eavesdrop on the discussions between Mazen Nnamdi Kanu and his lawyers?
Well, they would argue that he's getting all rather paranoid now.
No, it's not. No, if you agreed that because of electronic cameras and audio equipment and all the stuff in DSS would not be adequate for him to have concrete discussions with his lawyers in the defense of his case, and you're moving him from DSS to his court. But the court itself is also...
Yeah, but I mean, obviously the judge has more confidence in the court than the DSS facility.
Well, he's not... He moved the matter from the DSS facility to the court.
Yeah, that's what
hoping that the court will be an adequate place.
Yeah, that's
but the same court...
He obviously has more confidence
absolutely, but then the same court has the same issues as it would be at the DSS. The court is also wired electronically.
Yeah, but maybe the judge, because he's a judge in that court, I'm just speculating, has more control and more access to that kind of material.
So what if the judge was eavesdropping on his conversations with his lawyers? Would that not also affect the way and manner, the perception that he sees with the
well, I mean, that's purely
and
speculative.
would also lead to bias?
Yeah, that's speculative. But let's move away from that. Usually the decision by someone to fire his lawyers and represent himself tends to be a tactical move. It's sometimes used by defendants hoping to challenge the system. I mentioned that at the outset, and potentially gain an acquittal. They believe that by representing themselves, they can control the narrative and create reasonable doubt. But that strategy has also been known to backfire. I give you one example, and it's probably an extreme example, and I don't mean to kind of link it to Nnamdi Kanu, but if you remember the mass murderer in America called Ted Bundy, who was eventually executed. I mean, he got in, his lawyers were trying to arrange a plea bargain for him to get 75 years in jail, in other words, life imprisonment, and he got angry and fired all of them and said he was going to represent himself. And he ended up being found guilty, condemned to death, and executed because he did it himself. Whereas the lawyers had already made a plea bargain arrangement which would have kept him alive.
Well, let me tell you something, Doc. I don't know Ted Bundy, but
I don't know him either.
But I know Nnamdi Kanu. If you were in court today listening to Nnamdi Kanu, you will come up with the absolute impression that this is a very cerebral man. He understands the law. He also understands the challenges that are facing him.
So you think he got a better shot representing himself than the people who have represented him for quite some time? Senior advocates of Nigeria.
He made a decision.
Yeah.
He made a decision with the lawyers yesterday, which included the senior advocates of Nigeria. I'm sure they gave him proper legal advice. And I'm sure that he listened to all their suggestions to him, their briefings to him, and he chose otherwise. Like Kanu Agabi said today, that after the meeting, they came to court today to honor the court, and I swear to honor Mazen Nnamdi Kanu's request that they be debriefed, and that they respect his opinion.
Right.
And Mazen Nnamdi Kanu in court says that for now, he used the word for now, I am standing alone to defend myself. Doesn't mean that tomorrow that you will not see new sets of lawyers, which may include the current lawyers that have been debriefed. Right. But the most important thing for Nnamdi Kanu and everybody who is supportive of him is to ensure that everything that is going to be done goes towards fair hearing, and that that every opportunity is given to him as stated in the Constitution.
Right. The point is that he's not asking the court to give him time to choose a new set of lawyers.
No, he has not. Even
he's saying that he's going to represent himself.
No, he doesn't need to ask the court.
Right.
Even if he brings a new lawyer into the matter that's completely different from the existing lawyers, the lawyers will come under Section 36(6)(b).
They still need time.
They still need time.
Yeah, to familiarize
themselves with the case. And the evidences that have been put forth by the prosecutor, even if Nnamdi Kanu is taking over his matter, he still needs time to go through his trial files, know the evidences that have been put forth, also be aware of the 23 witnesses that he's already given to the court, and the court has issued summons for all the 23 witnesses and are compelling them to come and testify. So there's got to be adequate time. You don't expect that within the 6 days already given, 1 day is gone, that he has 5 days to prepare his defense. That's why I was saying that if anything goes contrary to Section 36(6)(b), then he definitely is going to lead them, make the trial to be a nullity. So he has to be given adequate time to look at his case file. To first of all, find out whether Agabi and the other team have given him his case file. He can't study everything tonight, so he needs adequate time. And then the facilities to be able to ensure that
we'll
he prepares himself very well.
Right, we'll watch and see how that develops. Meanwhile, of course, one of his lawyers, Aloy Ejimako, who stuck out his neck by becoming a bit more activist and taking part in the Free Nnamdi Kanu protests on Monday, is under arrest and is being charged with various offences. What's the story there? I understand you've been to see him in detention.
I went there today. I went there 2 days ago and today to visit with him and the other co-accused, Kuje Prison, to visit with them, and hopefully tomorrow the matter was adjourned by the magistrate court till Friday, which is tomorrow, of which we hope the offences being charged are bailable offences, and that the judge will adequately grant bail to allow them, especially Ejimako, who is the engine house or the secretariat of the Nnamdi Kanu legal team, to arrest him the way they did and to detain him the way he's also, you can say conspiracy theorists.
Well, I mean,
are saying that he was done deliberately. Yeah, but to ensure that Nnamdi Kanu is devoid of Ejimako's substance.
Well, that's one way of looking at it, because Bayo Onanuga, the special advisor on information and strategy to the president, has called for disciplinary action against Mr. Ejimako for what he called professional misconduct.
What professional misconduct? Well, Ejimako is a lawyer by profession.
Right.
He's a Nigerian citizen by profession, entitled to the provisions and to the protection of Section 40 of the Constitution of the Federal Republic of Nigeria, that says that he has a right to peaceful assembly and association. So why is it different? Because he's a Ejimako, and then he is no longer entitled to that because he's a lawyer. What about the doctors that came for the protest? What about students that came and many other people that came?
Well, yes,
are they not entitled to the same protection there? So it goes to that pattern, Charles, that I keep saying every single time, that when it comes, especially in the administration of criminal justice, there appear to be two sets of rules in this country, one for the Igbo man and another for every other
but of course,
the
man who organized the protests, Omoyele Sowore, has himself been nicked by the police.
Well, I had that today.
Yeah, we saw the video.
I had that today.
We saw it, we saw the arrest, and it's,
yes, I had that
he's
today.
been arrested.
He's been arrested, but what took them that long if they were going to arrest everybody? Why didn't they arrest everybody all at the same time? Because of the outcry on what may have appeared to be an injustice, particularly on one particular race or one particular tribe, the Igbo tribe, and then maybe just like they said, if you look at what the CPO of FCT said, that is almost like an injustice. They have arrested so many others, and then the person who organized the protest was never arrested.
Right.
But even Sowore has not committed any crime by, protesting under Section 40 of the Constitution.
They claim the reason why Bayo Onanuga was calling for sanctions against their lawyer.
Did they give Tinubu sanction? Did they give Tinubu sanction when Tinubu was protesting himself?
Let me just make the point. The reason, I mean, they're different contexts. The
reason,
hold on, let me just make the point. The reason is that, according to them, there was a court order preventing that.
Preventing them from going to the villa.
Preventing parts of that protest from
going to the villa. Where were they arrested? Were they arrested?
But that in violation of that rule, which is why he's saying that there is an issue of profession. I mean, I'm not a spokesman for him. I'm just telling you why he said that and why also Sowore has been arrested. But let's move on from that because we're running out of time. I mean, I asked this question of Mr. Sowore a few days ago because he was here on the night of those protests. With all the dust that's been raised by the protests and everything else in between, is that likely to make things better or worse for Mr. Kanu?
No, for me, every opportunity to draw the attention of the state to Nnamdi Kanu and the apparent injustice in the prosecution of Nnamdi Kanu. The judge is Yoruba. The prosecution team, all of them are Yoruba. The Attorney General is Yoruba. Mr. President is Yoruba. It appears that, for some elements within the Yoruba, community are looking at this as a new civil war between the Yoruba and the Igbos. It shouldn't be like that.
Yeah, but you're the one who's saying that.
No, but it's the reality.
No, well, I mean...
It is the reality, Charles.
It depends on how you interpret it.
No, but it is the reality.
Right.
Who is superintending the prosecution of Nnamdi Kanu? It's a Yoruba judge. It's not an
so you're saying that there is
Who is the prosecutor? It's the Yoruba prosecutor. Who are the prosecution team?
Yoruba. You're saying that
the Attorney General is Yoruba.
Are you saying there is a conspiracy,
Absolutely.
or there is the perception of a conspiracy? Which one are you talking about?
If you look at the way it is going, and they are resilient and adamant in seeing that Nnamdi Kanu is not given adequate provisions of time, adequate facilities to ensure that he has adequate provisions for his defense. So if you see how it is going, one may have the perception that it's a conspiracy of a few Yoruba people against the Igbos. So that's the impression that is out there. It's not just me that is talking. I mean, how can you expect somebody? You're saying that, okay, you have ruled so that you cannot go back. Every other thing will be done in presentation of your addresses. And then you have a holistic judgment.
Anyway,
who does that?
Yeah,
there are jurisdictional issues that needs to be.
Well, I'm not holding brief,
and I'm not a lawyer, so I'm not holding brief.
But I'm not holding brief for anybody. But I don't think it's fair to make an allegation against a set of people when you haven't got a scintilla of evidence to support the point that you're making.
Charles, I just gave you an instance. Excuse me, sir. I just gave you an instance. The judge is Yoruba. The judge is Yoruba. Well, it's not fair for the injustice that is being meted on Nnamdi Kanu.
Anyway, let me ask you this. Let's turn away from it because we literally got a minute.